All right. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw an eye, give their attention to the court, now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court, both to those who are in the court this morning and to those of you who may be watching us on our live stream. I understand we have several of Justice Wall's appellate advocacy students with us this morning. Is that correct? Some of you want to wave and tell us. So that's a good group. So we are really excited to have you here and hope that you find this to be a valuable experience. I'm confident you will. So with that, I'll ask Mr. Doug Shima to please call the morning docket.
Thank you, Your Honor. The first case on the 9 a.m. docket for Thursday, September 12th, 2024 is appeal number 125283, State of Kansas versus Gina L. Wilson, Sedgwick County, briefs both sides.
May it please the court, Peter Mashaney for Gina Wilson, present and ready for argument.
May it please the court, Assistant District Attorney Julie Kuhn on behalf of the state, present and ready for argument.
Second case is appeal number 126550 in the matter of the wrongful conviction of Jason Mashaney, Sedgwick County, briefs both sides.
Morning, may it please the court. Solicitor General Anthony Powell appearing on behalf of the state. I'm present and ready for argument.
May it please the court, Laurel Driscoll for appealee Jason Mashaney, present and ready for argument.
Your Honor, that concludes the docket for the week of September 11th through 12th, 2024.
Okay, thank you. For those that are our students in the audience and those who are watching online, I might take just a couple of minutes to kind of explain a few procedural things that bring us to today and some of the background, I guess. In terms of, we have one case that is a petition for review, which means that that we have granted from a decision by the Court of Appeals. So the other case is a direct appeal from a district court. We look in any of our appeals at the briefs that the parties have filed for us. In the case of the Court of Appeals, we also have the Court of Appeals decision and then the petitions and any briefs that were filed after the Court of Appeals proceedings that will often focus or if when they're helpful, most often focus on the Court of Appeals decision and what the court did there correctly or why they feel that there was error there. We will also look at the court record from whatever the trial proceeding was. Sometimes it will just be paper motion proceedings. Sometimes it will be evidentiary hearings, in which case we will have transcripts and exhibits and those types of things. In addition to that, we will have a research memo that's been prepared for the court by our internal staff that help us with the questions. So as we have reviewed that material, we have made notes. Those are on our computers or on paper. So you'll see us referring to those often as we begin to ask questions or have a dialogue with counsel about issues. Sometimes it may appear we're distracted by that, but please know that we are listening actively as we're engaged in looking at those notes because we're just trying to compare and hone in on specific points and issues that help us improve our understanding of the arguments that the advocates are presenting to us. With that explanation, I will ask the counsel in 125283, State of Kansas versus Gina Wilson, to please come forward. All right.
May it please the court, Peter Meharry for Gina Wilson. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is granted. Thank you.
Thank you. This case is before this court on a petition from the Court of Appeals on one issue, and that is whether or not the search, or I should say the traffic stop, was measurably extended beyond the time necessary for the traffic stop to allow the officers to run a police dog around a vehicle that my client was driving. And it's our contention, and we believe the record supports this, it was measurably extended. It was measurably extended by about 4 minutes, and while that may not seem like a long time, it is something that is in the record and measurably extended in violation of my client's constitutional rights.
Counsel, can I stop you there and
Sure.
jump in with my first question, which is, let's just assume that you are correct, that the detention of your client was unconstitutionally extended. Why does that, or how does that impact the search?
That impacts the search because once she is improperly detained, she can't leave, but you have to look at it, okay, we're doing the citation, we're done. Do we have any reason to extend the detention?
Right, well, I'm saying,
How
let's
is-
assume that you're correct about that.
She
And
could have
let me give you a hint what I'm
Sure.
driving at here. She could not drive the vehicle. She
That is
did
correct.
not have a license. So she was unconstitutionally detained,
Correct.
but the car is legally parked on the street. It's not, they're not detaining the car, are they? And a drug sniff is not even a search. I mean, they don't even need, so let's say they hadn't detained her and she walked away, and then all the other facts are exactly identical. How is the search unconstitutional?
The search is still unconstitutional because she was detained so that she could not, theoretically, if she was not detained, she could have went to her car, grabbed her belongings and left. She maybe not could have driven because she admittedly had a suspended license. They warned her, we don't let people just drive away when they have suspended license, but she could have grabbed her stuff and gone. Alternatively, she could have had somebody come get it. Now, timing wise, this court may not think that works, but had she been free to go, she could have grabbed her stuff, or she could have called somebody to get the car such that the search would not have occurred. She was not able to do that because she was in handcuffs at that point, and she was unconstitutionally detained. So we don't believe, and the district court did talk about inevitable discovery, which is where I think you're kind of going. Court of Appeals did not, because they did not find any constitutional violation. But we don't think that there was inevitable discovery to save this search, because from her standpoint, she was unable to leave, unable to grab her things. She was there looking at a rental property. That's why she pulled over. But she couldn't grab her stuff and go look at the rental property because she was in handcuffs.
But she was lawfully arrested, correct?
I would argue she was not lawfully arrested. She was only arrested after the dog hit, and we believe that is after an illegal detention. Like I said, she should have been free to go.
But there was probable cause that she was driving while suspended. Was that not an arrestable offense?
I believe it can be, but maybe I'm wrong on the record, but I believe the officer wasn't going to arrest her for that. My understanding is they decided to arrest her when the dog hit. It wasn't the driving while suspended that was going to get her arrested. It was a hit on the car from the dog. So even though she had a driving while suspended, I think the testimony was they warned people, don't go drive anymore, get it taken care of, whatever. But it's completely within my understanding, the officer's discretion whether or not to arrest. And he wasn't arresting her for driving while suspended. He was arresting her because of the dog hit.
Do you think the district court findings, though, constrain your argument? I'm taking you back, I think, to Justice Deagle's questions about the connection between the detention and the search, and maybe it's inevitable discovery, attenuation, I'm not sure what you call it, but the district court is making findings, it appears to me, about the timing and the sequencing of these events, to where your hypotheticals of her, maybe she could have grabbed the stuff and left. It doesn't comport with the timing according to the findings of the district court, does it?
Well, I think as far as the timing goes, she should have been allowed to leave. And I don't think there's anything to say that she couldn't have grabbed her stuff out of her car and walked away.
But is there any testimony in the record to that effect, that that was her intention, or
I think the
is
only
it purely just kind of the hypothetical?
For the most part, it is a hypothetical, but the state has the burden here, I think, to prove everything was constitutional and proper. But also, there was testimony that I think it's actually in the videos that, you know, they asked her, did you want somebody to come pick the car up? She certainly said yes. I don't think it was her intention. I think you can glean from that she just wanted to leave her car there, just abandon it. So I think the district court's findings as to timing said, look, the dog was there. But again, that still doesn't preclude her from going into her car, getting her stuff and leaving.
Let me stop you on that. I mean, I'm sympathetic. There's no reason why she wasn't allowed to leave. Let's just assume that. So now we've got two alternatives. One is she just walks away. I can go there. But now you want to, the dog's there. So if you're waiting for somebody to come and pick up the car, the dog's going to alert. So I don't think that path gets you anywhere unless, I mean, you can correct me, but I'm kind of ruling that out. But now you've got the, she could take her belongings. So let's go down that path. If they're letting her in the car and she's grabbing bags, an officer ought to be allowed to be around for that, to make sure she doesn't, you know, for officer safety reasons. I don't think they have to stand aside and let her freely get whatever she wants and the dog's there. So it just seems like, getting back to Justice Wall's point, it just seems like the facts don't quite work for your alternative paths, other than she could have walked away. And if she's walking away, there's a car there and the dog's there and the dog's going to alert. That's the way I'm looking at it. Now push back on that.
Sure. I guess two things. Number one, as far as her being allowed, if she is free to go, she should be free to go to her car and grab whatever she wants. Officers there are not. Either she's free to go or not. So if it's her car, her things, and she's free to go, she can go into her car and get what she wants. I don't think saying, well, the officer wouldn't let her in the car. That's not a crime scene. Nobody's saying it's a crime scene.
No,
They have no
just have to
basis for it.
stand there while she's getting her stuff. And if they're standing there while she's getting her stuff, there's a drug dog there.
Sure. But that's not meaning that the drug dog is up there sniffing around her. If she's going into her car to get her stuff, she should be able to do that regardless of what the police are doing. Second, just because the drug dog is there doesn't mean the officers would have searched. Maybe they would have, maybe they wouldn't. I don't think there was testimony as to what they would have done had she walked away and the car was left there. I think the inference that the state wants you to drive, of course they would have searched it. They were already there. But I don't think the record necessarily shows that. But most importantly, if she is free to go, which she should have been, she can do whatever she wants with her car. I mean, she could have drove it away. Not a smart move. But if she's free to go, she can do what she wants.
They would have just arrested her.
Like I said, not a good move. But she has to be free to go. And you can't say, well, she's free to go, but we're putting all these restraints on her. That's not free to go.
Well, but now you do have an additional fact besides the traffic violation for which they start. Now they have the fact that she's got a suspended license. So what effect does that have on whether or not the stop can be extended past what would have been constitutional for the traffic violation? Anything?
I don't think the driving while suspended does anything. the officer said, I think the citation was gonna have both driving while suspended and failure to use turn signal. And he testified, I was done writing up the citation roughly the same time the drug dog got there. So I don't think that itself allows the officers to extend it, because they weren't gonna arrest her for driving while suspended. They only put her in cuffs after the dog hit on the car.
Didn't they have to figure out what to do because of the suspended license?
They were writing a ticket. I mean, that's what they were doing. As
As I
far as,
understand under the facts, they were talking to her about, we're not going to be able to let you drive away now because of your suspended license.
sure,
Are you going, what are your plans? Are you going to have somebody come and pick you up? They were explaining that to her. So that's going to take a little bit of time. And you would agree that that time would be a legitimate extension of the stop, right?
except in this case, the officer testified he was done with the citation, which was for the failure to use turn signal and driving while suspended, roughly the same time the drug dog got there, but several minutes before the drug dog hit. So they
Okay.
were not extending the stop because they were trying to figure out what to do because of the driving while suspended. They were extending the stop so that they could run the drug dog around the car. And as far as what to do, this is on the video. They asked her, and this is after she's handcuffed and put in the car, do you want somebody to come pick up your car? And she said yes. So I don't think the driving while suspended in any way extends it to save this search.
I have a note that at record volume 4, page 24, the officers testified that they always intended to arrest her once they asked her to exit the vehicle, as an arrest would provide another way for them to accomplish their ultimate goal of searching the vehicle for drugs. So, and I'm not, I may, that note may be incorrect, but just assume with me for a second that it is correct. And how does that impact your argument? What would your argument be under that scenario?
Well, if that is true, that they were going to arrest her for the driving while suspended, admittedly, I think that does change things. As far as my argument that she should have been obviously free to leave and free to get her belongings and leave. And I'll look at the record too. But my understanding was the officers testified that they had discretion whether or not to arrest for driving while suspended. And that's,
And I do think from what they do say that at page 27, that they have that discretion.
and
And can you just provide a citation and an appearance date to the offender? So.
yeah, and if you look at the video, this first officer who initiated the stop was writing the ticket. The second officer was standing on the side of the street with my client and talking with her throughout, kind of trying to explain what they were doing. It is only when the dog hits that they put her in cuffs. So I think the evidence shows that they only were going to arrest her if the dog hit. If they didn't find anything in the car, they were just going to give her a citation to say, have a nice day.
Well, if that's not true, if they decided to exercise their discretion to arrest her simply because they wanted to extend the stop so that they could search the car for drugs, is there a problem with that? Is there a constitutional problem with the way or the reasons they exercised that discretion?
Under case law, as far as officers exercising discretion, whether or not it be you have the discretion to arrest this person for crime X or let them go on a citation. I think the case law would be that's up to the officer. And if they do it to extend the stop, we all know this court allows, as well as other courts, allows pretextual stops of cars. So I'm guessing that the case law would say that's fine, whether or not I agree with it or not. But here, I don't think that's the scenario. I think the evidence shows that she was only going to get arrested when the dog hit.
I want to make sure my notes are, comport with your recollection. I've got the K-9 arriving at the scene at 4:51 p.m. and an officer Bailey completes the citation and steps out of the car 40 seconds later. Does that fit with your
That's
recollection?
my understanding of the record.
Okay.
Yeah.
And that's why I'm saying the timing on this thing is so tight.
It is very tight. My recollection of the record is that the drug dog arrives at 4:51, as you mentioned. Officer Bailey testified that he was done with that citation, gets out of the car roughly 40 seconds later, confers with the canine officer. They then do the runaround of the car, and the dog hits on the car at 4:55. While that is not a huge amount of time, I would point out in Jimenez, I'm not sure how it's said. The entire traffic stop, I think, was like 7-ish minutes. And part of that traffic stop involved the officer asking a bunch of travel questions, which this court said immeasurably extended the stop, and that was improper. So it's not the amount of time, it's that it was extended. You don't get to violate the Constitution a little bit. You either do or you don't. And for that reason, we believe there was a violation here, and we would ask that this court reverse the Court of Appeals and also the district court on that matter. Thank you.
May it please the court, Assistant District Attorney, on behalf of the state. It's our position here that the Court of Appeals got it right. We are talking about 3 minutes and 20 seconds.
There's no de minimis exception to our case law that says you don't extend a traffic stop beyond the time needed to complete that stop, right?
Correct.
So
However, it does say measurably extend. So it's our position, the facts here in this case, this stop was not measurably extended.
and is there any authority that has defined measurably as anything other than the time needed to complete the processing of the basis for the stop?
Not that I discovered. We have not.
But that's an argument you're making here.
Correct,
Okay.
correct. That in this situation, this is not a measurable extension. As the timing is important here, and it's very well set out in the record. Additionally, you have video of the stop, but at 4:51, the canine arrived and the officer here was still completing the citation. The purpose of the original stop remained in progress and had yet to be completed. Then he testified that approximately 40 seconds later, he completed the citation, briefly spoke with the canine officer, and then the canine ran around, did the sniff around the car and indicated at 4:55.
But did he tell her that she was free to go after he handed the citation to her?
I don't recall.
I mean, I don't know of any evidence in here about that.
Right, and I don't recall, because it has been a while since I saw the video, if when he completes that citation, if he goes to her or if he immediately speaks to the canine officer before he runs the dog around the car.
And would you agree that a person is seized in a traffic stop from, when the lights go on and they pull her over until she's told she's free to leave?
Yes.
Okay.
Yes. And in here, there's been many conversations about she could have walked away, this and that. She was not handcuffed this whole time. She was on the phone with a friend talking about what was going on, and the video will show that during that time, she also never asked for that person to come and get the car. And that it was at some point, I mean, she knew that she was suspended. She knew that she could not drive. So she knew that she was not going to be driving away in that car. So our position is the Court of Appeals, as I stated, got this correct, and that this 3 minutes and 20 seconds did not measurably extend this stop.
What would be measurable then? I mean, I can measure it. It's a quantity of time.
True. I believe in this situation, in situations like this, measurably, I think it has to be something, honestly, in the 20 plus years that I've been doing this and dealing with dog sniffs and measurably extend, I've never seen one this short. So I think in many cases, there have been some that have been longer than this, and courts have found it to be okay. 3 minutes and 20 seconds, when he has testified that he did nothing to extend the stop. He was not doing anything purposely to extend it to get that drug dog there. He was doing everything he would normally do with a traffic stop.
What is the evidence in the record for that? Because it seems very coincidental to me that he finished writing the ticket contemporaneously with the dog arriving. Do we have anything in the record to show us how long it took him from walking back to his car to write the ticket? I mean, he did not write the ticket, you know, I mean, he was not engaged in writing the ticket because he first called for the dog, right? So
at 4:36, he conducted the traffic stop. At 4:42, he's back in his car. At that time, he confirmed her license was suspended and he requested the K-9 unit. Then the K-9 unit, during that time between him requesting the K-9 unit, determining her license was suspended, he's doing the records checks through Spider. He's checking
right.
for
So there's
warrants.
13 minutes between when
There's
9 minutes. 9 minutes he's writing a ticket. Is there, and you just stated that he wasn't doing anything in that 9 minutes, you know, that is that how long it takes to write a ticket?
Well, I believe he testified, I mean, the record will reflect, he testified as to how long it can normally take to do all of those record checks to
Okay.
write that ticket, because he is not,
Tell me where that is in the record. I didn't
it
see.
would be in his testimony. I would have to,
Okay, that's fine.
yeah, it would be Officer Bailey's testimony.
But none of
To
that's
reflect
really
that.
relevant, right? Because there's no allegation by the defendant that the officer drug his feet while he's processed. I mean, that could be an issue.
It could be, correct.
It's not an issue here.
No, it's not. It's not. And additionally, you do have the district court who weighed his testimony, found the officer credible. There's no question here as to his credibility that the coincidence of him finishing up that ticket. The officer, his testimony was weighed and found credible, and the district court determined that this was not a measurable extension. Alternatively, if you are to find that this 3 minutes and 20 seconds was a measurable extension, it's our position that there was also reasonable suspicion here to justify extending the stop to allow that K-9 to sniff the car. And that goes back all the way from the officers observing defendant stop at a suspected drug house, go inside for 3 to 5 minutes and leave, then following and observing her conduct a traffic violation, and then defendant telling the officer that she was looking at the property to rent that she happened to stop, that they stopped her in front of, and she had simply stopped at a friend's house to ask for directions. The officers testified that their suspicions were heightened due to her explanation of her actions, feeling that it was unusual to stop someone who said they were lost, had stopped at a friend's house and asked for directions, and then just happened to be pulled over directly in front of a house they were looking at.
Did they have knowledge of her prior drug history? In hearing your synopsis, is that a part of the equation also, or when did they know that?
He finds that out when he is doing the record checks, the license checking for warrants. He discovers her prior history of narcotics possession. So that is it's a part of the whole totality of the information that he discovers and has. In addition, he had been doing an investigation on that home a drug investigation, had done a trash pull the day before and found evidence of narcotics distribution. So putting all of that together, the officer had a reasonable suspicion and was able to articulate a particularized suspicion that defendant was in possession of illegal substances.
Isn't one of, I don't know, what about the officer testimony that they intended to arrest her once she made the admission that she was suspended, and they corroborated that? So I think, as I understood the arguments at the district court level, there was a state statute gave the officer discretion whether to arrest or not. But maybe department policy regulated that discretion. Is that relevant? If state law grants an officer discretion to search, does it matter what the department policy is when we're conducting a Fourth Amendment analysis?
Here, I don't know, and I believe that policy is part of the record. I think it's a defendant's exhibit. But I don't know that it necessarily matters here what their policy was with the driving while suspended. And you're correct. He had discretion to give her a citation and let her walk away, or to arrest her. It is a driving while suspended is arrestable. So I think the defense probably admitted that policy somehow in their argument, but I don't know that it necessarily affects what happened here. I don't know if that answers your question.
I didn't know if it was legally significant, even if the department policy limited that discretion, whether that is a relevant consideration in a Fourth Amendment analysis.
I didn't think about it that way, but I don't know that it is. I think all of the facts, factually looking at this case, I think this was, it was a solid stop. It was a solid search. And we don't have a violation here.
And the basis for your saying that is you think officers, after the seizure ends, have a cushion period to still do a search?
I don't know that they have a cushion period. I mean, we're not saying that they can just.
There's 3 minutes here. You're trying to say that doesn't measurably extend. I interpret that to mean the officers ought to have at least 3 minutes of a cushion to still keep someone seized and do a search.
I don't know that we're saying that there's a cushion, but again, going back to measurably, we don't feel that what occurred here on the facts of this case, that this was a measurable extension.
I mean, it seems to me if you're saying measurable extension does not equal 3 minutes from, where I sit, that seems like there's at least a 3 minute cushion.
I guess we're saying two different things, or we can agree to disagree, but yeah, it is our position that this is, on the facts of this case, this is not a measurable extension.
So taking that one step further, what would be a measurable extension? I mean, if we were to adopt your argument and say, in this case, the 3 minutes and 40 seconds was not, or 3 minutes and 20 seconds was not measurable. What about 4 minutes and 20 seconds? What if it had been 4 minutes and 20 seconds?
Well, I think you need to look at everything that occurred. I think if you're looking at the officer's actions, once he finishes the citation and he does things purposefully.
But under these facts, what if it was 8 minutes and 20 seconds? Would your argument be different?
Under these facts, I think the important piece is that the dog was already there. I think many times you have situations where the citation is completed and the dog hasn't arrived yet.
Okay, so
that's the problem.
So if the dog had arrived but took 8 minutes and 20 seconds to alert, what would your position be? I just want to know if we're going to adopt what you say when the next case comes. what are we supposed to do?
Well, I don't think this court has to set out a specific time frame. I mean, we do have measurable already in the case law.
Then that's what I'm
think-
asking. What's measurable? Is 8 minutes and 20 seconds under these facts? Is that measurable?
Well, under these facts, we don't have that. That's the problem.
But I'm
If
giving you a
these
hypothetical.
facts-
Yeah, I'm giving you a hypothetical. Everything's the same, except it took 8 minutes and 20 seconds to alert.
Well, I would find it highly unlikely for a dog to take 8 minutes.
I mean, is it a yes or a no? I mean, is that measurable? Is that measurable?
I would say that could be measurable.
What about 6 minutes and 20 seconds?
It would depend on the
No, the exact same facts.
exact same facts.
Yeah.
The problem is here, that is not what happened.
But I'm giving
And
you a
I understand you're
hypothetical.
giving me a hypothetical, but it's an unrealistic hypothetical under these facts.
Thank
Let
you.
me try to see whether I can articulate what I think you're saying. These are human endeavors with people who have, there may be terrain differences, there may be, somebody may have a problem with a shoe. It's a human endeavor, both on on everyone's side. It is not something where we're in a surgical place where we're making microchips or where we're doing something that does require second to second surgical precision. Is that what you're talking about when you say measurable extension has to take into account all of those human and environmental facts?
I think that is a good explanation and a good description. It is a fluid situation. Now, we are lucky here because we do have these timestamps of what occurred. We also have the video to see what occurred. But yes, you have a number of factors when you are dealing in a situation like this. And I think that's where you're looking, when you look at measurably. I mean, in the state's opinion, 3 minutes and 20 seconds is not a measurable extension. And I don't know how to say that any better than this amount of time does not equate to measurable.
But how do we reconcile that then? Because the case law talks about measurable extension. Measurable is a period of time. So even if all of those human factors, how fast somebody talks, how fast somebody walks, I mean, when he's done, he's done. And so time can be measured. In this case, it was measured.
Mm-hmm. And I would agree with that. And that's why our alternate here is, should this court determine that even 3 minutes and 20 seconds is a measurable extension of this stop, that we also have reasonable suspicion. The officer had reasonable suspicion that there was a possible crime being committed. But I agree, it's very hard to put a finite, because of all of the factors that are in consideration here, to put a finite definition on what this is. And I think it depends on the facts of the cases. And that's why we feel that in this factual situation, this was not measurable.
But isn't a possible reconciliation that we may look at the amount of time it took him to write the ticket and say, is that a reasonable amount of time given all the facts and circumstances? But that it changes once he's done. Once he's done, then we start measuring with precision.
That is possible. If there are no other questions, we would simply ask that you affirm the Court of Appeals and affirm the convictions in this case. Thank you.
Mr. Meharry, you reserve 3 minutes.
Thank you, Your Honor.
Mr. Meharry, before you get started
Sure.
on Ms. Coon's last point on reasonable suspicion, what does it take? Here we have trained law enforcement officers knowing that this driver has a history with drugs, going to a drug house that they're surveilling, stopping. I don't know how you want to characterize the story, but it's maybe an odd story about her presence there, leaves shortly thereafter, coupled with the other things that they learn at the traffic stop. Why isn't that reasonable and objective standard for reasonable suspicion? Or what more is needed?
Sure.
Where are you at with that?
We don't believe it is reasonable suspicion because what you have here is, as you said, they saw her stop at a house. They were surveilling for possible drug activity. Stopped for a short amount of time. What she told the officers was she asked a friend who she named her friend who was the subject of the investigation and said she was simply asking for directions to this rental, which is true. The landlord testified, she told my client, it's on this street. My client not familiar with that area, so she asked a friend who lived in that area for directions. The officers testified, she told us that at the scene. The officers testified that certainly seemed plausible. The officers testified we had no reason not to believe her. Further, her drug history, when the officers pulled it up, it also showed that her drug history was old, from 2010 or before. So what the state wants you to do is just look at certain things. Reasonable suspicion is based on the totality of the circumstances. And when you look at everything here, what you have is a person who's lost, gets directions from a friend, pulls over to the house she's looking at. And I know this wasn't argued below, but I did watch the video and sure, to me, it looks like she's pulling over before those sirens come on, but that's just me. So you have somebody simply driving in a neighborhood to a rental house. And I don't think the fact that she stopped at a friend who's under investigation, simply being in a high crime area or in a drug house in and of itself is not enough. And the fact that she has criminal history, which is old, I don't believe even when you marry those two things is not enough for reasonable suspicion. And those are things the officers knew, but they simply chose to ignore when they're talking about their reasonable suspicion. We don't believe it's reasonable suspicion.
Counsel, real quick, would you agree that in order to achieve your ultimate goal of suppressing the drug evidence, you would have to demonstrate that the search of the vehicle was unconstitutional?
I mean, I would say in kind of a roundabout way, in that there was no reason to extend the stop. They measurably extended the stop improperly. And there was
Right, but you
not,
still have to show the search of the vehicle was unconstitutional, right? I mean,
well, I think I have to show that the search was a result of the unconstitutional detention. That the only reason, and this gets into a little bit of the inevitable discovery, the only reason they were able to search was because they measurably extended the stop in violation of my client's constitutional rights.
So you think if they had told her she was free to go, they would not have been able to search the vehicle? Well, they would not have been able to perform the drug sniff.
I don't think they necessarily would have had that opportunity.
Is there any evidence in the record that makes that plausible at all?
I think there is evidence that if she would have been able to go, clearly she was frustrated. She was being held there, detained there. I think the evidence is that she would have got her stuff and went.
Well, I went and looked while you were sitting down, and I'll ask you if you agree. My read of the record is that the only evidence about what she would have done is that she would have left. The officers testified she wanted to leave. There's nothing at all about, I mean, even if we enter into that sort of speculative land about her trying to get the drugs out of the car with the drug dog and the officers there.
Well, I think
seems highly
I mean, to me,
is there any evidence of that?
If you're there and assuming that and she all along stated these were prescription, but if you're there and you're free to go and you've got officers there, I think I would grab my stuff and go. I don't think that's out in left field.
Will you
So
remind me, was it found in her where was it found?
if I remember right, it was found in an envelope in the center console of the
In
car.
the center console. Thank you.
I'm pretty sure on the envelope part, and I think on the center console part, Your Honor. So I think, like I said, I think the unconstitutional detention allowed the officer to search, which resulted in finding of the drugs. And without that unlawful, unconstitutional detention, they would not have been able to do that. One thing I did want to point out, Justice Luker, you said, you pointed to volume 4, page 24. That was the testimony of Officer Isham. I don't know if I'm saying that right. But he did talk about whether or not they will arrest for driving while suspended after a pretextual stop. And I'll just quote it. He said, but we had talked about it at some point if they are suspended. This is a normal circumstance for us on a pretextual stop. If somebody is suspended, they are probably going to go to jail because that does allow us another avenue to get inside the car. So he isn't really talking specifically about this situation, more generally. And if you look at Officer Bailey's, and I'm looking at kind of page 35 through 38-ish, he talks about they have that discretion to arrest. But when you look at how this traffic stop played out, Bailey said to Isham, look, she's got a suspended license. I'm calling a drug dog. They only put her in handcuffs when that drug dog hit. That was the reason why they arrested her. So I don't think they can rely on driving while suspended to keep my client there. If there are no questions, we would again ask this court to reverse the Court of Appeals as well as the district court in this matter. Thank you.
Thank you. Thank you to both attorneys for their arguments in this matter. The court will take this case under advisement. Again, I would just add a little explanation to that for the benefit of the students and others. What we mean when we, by the practical steps that are result from our taking this case under advisement are that later today, the court will begin discussions about what the outcome of this case should be. And those discussions will continue until we resolve the various questions or issues that we may have, which sometimes will result in more briefings. Sometimes it will result in more research on our staff's part or digging more into specific questions in the record. Or sometimes it will be resolved just from the initial conference. Once that preliminary decision about outcome is made, one of the 7 of us will be assigned to write a draft opinion for the others to look at. If we don't agree on the outcome, then there may be concurring or dissenting opinions that are drafted as well. And once those opinions are in draft form, they're circulated to all of us. We will then respond, make suggestions, perhaps have back and forth, and sometimes that will even spin off yet more opinions based on once we read it and see how it's written. That may cause us to feel like we need to write separately. Eventually, this will resolve in 1 or more filed decisions. We file our decisions most often on Friday mornings, rare exception any other time. When those decisions are filed, there is a public statement that the decision has been released with a brief summary of the outcome. And in addition, the copy of that decision is posted on our website, the KS Courts website. We remind people as we visit with Kansans that one thing that sets the judicial branches apart in large part, in most ways from the executive branch or the legislative branch, is that you will have a document that leads you through the thought process and the reasoning of the court in reaching its decision. We have that level of transparency that we often don't have with other branches that give us, hopefully, give you a better insight into our decision process. Thank you, counsel, for your patience and as you sit and listen to me give that explanation. Again, we appreciate your arguments. Thank you. I'll now call 126-550 in the matter of the wrongful conviction of Jason Mashaney.
Good morning. May it please the court. Solicitor General Anthony Powell, appearing on behalf of the state of Kansas, the appellant in this case. May I reserve 3 minutes for a rebuttal?
3 minutes is reserved.
Thank you very much. The state is asking this court to reverse the district court's judgment on behalf of Mr. Mashaney. The district court granted a certificate of innocence and awarded damages in the amount of $414,000 to Mr. Mashaney. For the benefit of the students that are here, I'll give a brief kind of history of this case because it is long running.
You even had a piece of this case at one point.
I did. And I will tell the court, I did visit with my subordinates about that. Since this technically is a different matter, I was a district judge in the 1507 in this case and was reversed by the Court of Appeals. So that's my small bit in addition to today. But Mr. Mashaney was charged way back in 2003 with a single count of aggravated criminal sodomy, 1 count of aggravated indecent liberties with a child for acts committed against his 5-year-old daughter. The charges were later amended to add an alternative count of aggravated indecent liberties. The first trial ended in a mistrial. The case was retried again, and Mr. Mashaney was convicted in July of 2004 of aggravated criminal sodomy, a severity level 2 person felony, and aggravated indecent liberties, a severity level 3 person felony. Prior to sentencing, Mr. Mashaney raised claims of ineffective assistance of counsel. After a hearing by the trial court, the court rejected those arguments. He went up on direct appeal and his convictions and sentence were affirmed. He then filed a 1507 in the district court, which when I was district judge, I denied on appeal. The Court of Appeals saw it differently, felt that he had raised significant claims of ineffective assistance of counsel that warranted an evidentiary hearing. It went back to the Sedgwick County District Court, and the trial court, after an evidentiary hearing, found Mr. Mashaney's, both his trial counsel and his appellate counsel, ineffective and ordered a new trial. It was at that point in 2011 now, where time has gone by, and the state and Mr. Mashaney reached a plea agreement. And that plea agreement provided for Mr. Mashaney to enter a guilty plea pursuant to North Carolina versus Alford to 2 counts of attempted aggravated battery, each severity level 6 person felonies, and 1 count of aggravated endangering a child, a severity level 9 person felony. Mr. Mashaney was given a downward durational departure and was sentenced to 72 months in prison on February 24th, 2012. Because of the time that he spent in prison under his prior conviction, he in essence had in excess of jail credit, and so he basically served no time for his new convictions. Shortly thereafter, Mr. Mashaney sued the Board of Indigent Defense Services as well as his 2 lawyers who had represented him. The district court dismissed his claims, finding 1, that bids could not be sued, and 2, the court found that Mr. Mashaney couldn't prove his actual innocence due to the fact that he entered into an Alford plea. The Court of Appeals affirmed that, but this court granted review, and in August of 2015, while it affirmed and agreed with the Court of Appeals that bids couldn't be sued, it disagreed with the Court of Appeals and the district court's view that to prove legal malpractice, Mr. Mashaney had to show actual innocence. And so the case was remanded back to the district court. It was then that the lawyers settled with Mr. Mashaney on those claims for roughly $91,000. Subsequent to that, in 2018, the legislature passed what we now call the wrongful conviction statute, which allows those wrongfully convicted of felony crimes to seek redress in the courts for their wrongful conviction, those who have been convicted of a felony and served time in prison. Mr. Mashaney, in early of 2020, brought this present action for wrongful conviction against the state. There was a trial before Judge Comer, and Judge Comer agreed with Mr. Mashaney and found and granted him a certificate of innocence and awarded him the damages that I've indicated. It's the state's view that the district court erred here and that the district court should be reversed and the award vacated. And principally, it's the state's view that this case is controlled by the Doles case. And unfortunately, when we briefed this case, we didn't have the benefit of the several opinions that this court has issued over the past year, which have really clarified the law here. But it's the state's view that this case is really controlled by Doles. And in Mr. Mashaney's case, Doles, we think, teaches us that he had to prove two things. One, actual innocence, and two, that the dismissal of his charges were the result of that actual innocence. And that's where I think his case falls down.
Let me ask you about Sims, which preceded Doles, but interpreted a different part of the wrongful conviction scheme. And in Sims, the district court made a finding of these charges being effectively dismissed.
Right.
And it seems to me that's not aligned with the way we've interpreted the statute from Sims, which also honestly kind of is, to me, is a legal question where I'm more comfortable than when you get into Doles and what caused what and all that. So why is Sims not controlling?
Well, let me make 2 points about that. First, we disagree with the district court that there was a dismissal here. I'm just saying for the purposes of the elements, Mr. Mashaney can't even go to the next step, which shows that even if you assume there was a dismissal in this case, he can't show that that dismissal was caused by his innocence. The fact is that the case was sent back for retrial and a plea bargain was entered into because of the ineffective assistance of counsel claim. And so that was the basis for the amendment of the charges. I think the issue here was we've got a witness who was a young child when she first testified. They were clearly having problems. We couldn't secure her presence to testify in this particular case. So the record isn't entirely clear as to those reasons, but I think the record shows sufficiently that there is no showing, at least I think I can confidently say in the record, that the Sedgwick County District Attorney's Office made an agreement because of his innocence. Clearly, Mr. Mashaney entered into a guilty plea pursuant to Alford, and I think that's prohibits a finding of an actual innocence. But with regard to the dismissal, Justice Biles, I think you're right. Because he wasn't absolved of his criminal liability, and because the criminal proceedings didn't end at the time of the original remand, he can't say that the charges were dismissed at all. They weren't in fact dismissed.
Did the amended charges arise from the same set of facts or transaction as the original charges?
Yes. But I want to be clear, and I think I should be candid with the court. I spent a lot of time looking at that issue because the charges that he pled to obviously are different from the charges that he has originally charged and were vacated. The initial charges, of course, are sex crimes, while the ones that he pled guilty to are, in essence, attempted aggravated battery. And so in doing the research, I don't think would be accurate for me to say that they're lesser included offenses of the originals, but what I would say, I guess, the common nucleus of operative facts, for lack of a better term, are you have a touching, an unwanted touching, and harm. And so from that standpoint, I think it's the same. It's not something where, okay, he had his convictions for sex crimes vacated, and the state entered into a plea agreement in which he then pled to jaywalking or something like that. I mean, these facts, we're still looking at his conduct from that time period back in September of 2003, and that's what those charges are essentially for. And so,
Procedurally speaking, was there, I assume there had to have been an amended complaint filed,
yes,
and did that happen in conjunction with the plea agreement?
yes, it was filed actually after he entered his plea. The
So,
the
I like,
transcript of the plea talks about what the facts are, and it's basically
so that's odd. So he pled to
that
something
happened.
he
that
hadn't
would-
been charged with?
It just happens I mean, I took a lot of pleas where they've got it right there. We
Yeah,
do the record.
in other words, it's
Sometimes
all,
it
it's all
gets filed.
simultaneous.
But he read
Yeah.
basically the elements in the record.
The amended complaint is essentially that's the quid pro quo of the plea deal, essentially.
Yes. I mean, Mr. Mashaney testified at the hearing, at the trial, was that his interest was he wanted to not have to spend any more time in jail. He didn't want to admit to any sex crimes. And so the state, in order to, get the plea, basically, amended the complaint to reflect his actions, but take out those particular elements that Mr. Mashaney didn't want and limit his sentence to basically roughly to time served.
It is kind of odd. We have recanted testimony that absolves Mr. Mashaney of the acts that he was accused of and convicted of.
Well, we don't have actually recanted testimony. I mean, we have the father and mother and Mr. Mashaney claiming that the victim has recanted, but we actually don't have the benefit of her actually recanting.
Okay.
I think that's important. So I think that's an important difference.
Yeah, I appreciate that.
I mean,
but let's say we did have recanted testimony,
Okay.
and we both, that happens, that people are convicted and later absolved of the consequence of what occurred because for whatever reason, there's recanted testimony and the evidence is not truthful or made up or pressured, whatever happens in those situations. What is the pathway or is there a pathway when that circumstance occurs to getting relief under the statute?
well,
Or there might not
I'm
be.
sure the recantation is the operative word here. It seems to me that the two key elements are either actual dismissal, but this court has said in Sims that the criminal case goes away, or there's an acquittal. And this court has addressed a number of cases where it's sort of in between, and this is another one of those in between cases.
Yeah, I agree.
This court has never awarded anyone or upheld any award to anyone when you have something that's in between like we have here. This is very similar factually to what you had in the Spangler case. The Spangler case where he's tried for second-degree reckless murder, a new trial is ordered, and he's then convicted of the lesser included offense of manslaughter. And he's given a sentence that's less than the time he's already served. He made a claim under the statute, and this court said, well, you can't prove that your actions didn't cause your conviction and incarceration. The same is true here.
And
he just did it through a plea, but it's the same
I
thing.
understand.
a little bit to that point, in our recent decision in Doltz, as you know, the court emphasized the causal factor that is present in the statute.
Yes.
So my question is there anything in the record? Did the district court make any findings about causation in the record?
No, that's the problem. He didn't. It's almost like he skipped over that element. I think that's a fatal to the court's order in this case. I see that my time
From
is.
that, I think you agree that all factors A through D have to be established by.
Absolutely. Absolutely. Seeing no more questions, I'll sit down. Thank you.
May it please the court. My name is Laurel Driscoll. I'm appearing for the appealee, Mr. Mashaney, in this matter. And I want to jump in right into one thing that I want to clarify that was stated by opposing counsel in this matter. If the court looks at the record from the civil trial that was held on the wrongful conviction matter, it's very clear that the record actually does not provide any evidence, any argument whatsoever by the state that there was a reason that the state chose to enter an Alford plea instead of retrying Mr. Mashaney. I think the state, my understanding of his statement and his argument was that the state chose to go forward with the Alford plea instead of retrying because there were issues about getting witnesses or other evidence, and that's absolutely not true. If the court looks at the record from the civil trial, there was no evidence presented by the state whatsoever as to the reason why the state chose to enter an Alford plea.
Isn't that fatal to your client's claim under our recent decision in Doltz?
It's not, because there's some things that this court should take into consideration with that. First of all, it was an Alford plea, so he maintained his innocence with entering that plea. Second of all, the Alford plea, as was mentioned, those charges were completely different from the original charges that Mr. Mashaney was convicted of, both in substance. These were non-sex charges as opposed to what he was convicted of, which were sex charges, and also in severity. They were much lower in severity. The other thing that this court should take in mind with this Alford plea is essentially the state came to Mr. Mashaney offering him time served.
But and I understand all that, but you started out suggesting that the record is absolutely devoid of any evidence of causation. And highly summarized, I think the Doltz stands for the proposition that the statute requires a showing that one of three things happened caused by actual innocence. Either a reversal, a dismissal of the charges, or an innocent verdict. Not guilty verdict, I should say.
And our argument is that, like the district court found, Mr. Mashaney's original charges were effectively dismissed.
Sure, and if we grant you that, I just want to hear your response to, maybe you disagree with my characterization of Doltz or just think it's wrong, but I want you to talk about that causal factor. Like, even if the district court did find actual innocence, isn't there a requirement that there's a finding of causation?
And I think that Mr. Mashaney has been able to show that through what was presented during the civil trial in this case. One of the big things that Mr. Mashaney showed during the civil case is that there was actually a report by a child neurologist named Dr. Richard Gilmartin, who had a report that basically, it was very favorable to Mr. Mashaney in his defense, basically stated that the child had a skin infection, and basically came to the conclusion that in his 40 years of experience, he found it very improbable and unlikely that this happened.
But that all goes to actual innocence, right?
Right. And so this report, though, was never submitted as part of Mr. Mashaney's trial in the criminal charges. And the only thing that was presented by the state during the trial, if the court looks through that record, is the testimony from the victim. That was the only thing that was presented by the state. Mr. Mashaney was convicted. Later on appeal, when Mr. Mashaney appealed the matter and the court found that he had ineffective assistance of counsel for that matter, one of the reasons that the court found that he had ineffective assistance of counsel was that there was actually this report out there that stated that what he was alleged to have done was improbable, probable, or unlikely to have happened, but it was never submitted to the jury. And if it would have been submitted to the jury likely would have found him to not be guilty. And so that was part of the reason why the court found his trial counsel to have been ineffective, is because that was never presented. It was then that report for the first time came to light through this appeal. Mr. Mashaney's conviction was then reversed and remanded back to the district court, and the state then after knowing that report was now out there, having not seen it before, the state then decided to effectively dismiss Mr. Mashaney's charges and allow him to enter this Alford plea that was to different charges, less severe charges, allowed him to maintain his innocence, and gave him time served, which I think it's important.
It allows him to make, Alford pleas are kind of a hybrid type of plea. I took lots of those when I was at district court, but the ultimate conclusion and the finding and the warning and the caveat that's given to someone entering an Alford plea is it results in a conviction based on the facts that are presented to the court. I mean, it isn't a finding of innocence. It might allow someone who takes an Alford plea to claim innocence, but it's not a finding of innocence. Correct? I mean, isn't.
But Mr. Mashaney maintained his innocence through that. And I think it's important for the court too to keep in mind that by entering that Alford plea, he was released from prison that day. He walked out of prison that day. He didn't have to do another day of prison. If he would have said,
Not because he was innocent, because he pled to charges in which encompassed the time served that he'd already done in incarceration.
But these charges were also,
And they're based on the underlying facts of the original claim.
But they're non-sex charges. They're of a much lower severity. And I think one thing to keep in mind too is I don't think we can fault Mr. Mashaney for deciding I'm going to take this Alford plea and walk out of
no
prison
fault.
today.
Makes perfect sense.
As opposed to I'm going to go back to prison and await another trial, another year or two.
Perfect sense, but that doesn't necessarily equate to him being found in or a certificate of innocence. I don't think you can base that.
Well, I think what the court needs to keep in mind is we have both this report that came out and it didn't come to light at all until on the appeal. This court in the Doltz matter, it brought up the issue of having DNA tests, for example, if you have a person who's convicted of, for example, murder, they're on death row or life in prison, and it comes out that there's this DNA test that then shows that they had the wrong person. It wasn't this person who did it. And then they're released from prison and considered innocent. I think the court recognized, or what the court was trying to show, that was what its intent was with this matter. This is synonymous with that because you have a scientific report that wasn't provided in the trial on the criminal matters. It wasn't provided. It was favorable to Mr. Mashaney. And then you later down the road have this report come out saying that it's essentially impossible for what Mr. Mashaney was alleged to have done to have happened. And so it's very similar with later down the road getting that DNA test, it showing that they had the wrong person.
So if I can understand I think I'm following you, but let me just make sure. I'm going back to causation, the causation question, whether or not, the dismissal was as a result of innocence. And you're suggesting that when you put on evidence that there was newly uncovered evidence of innocence, and then subsequently the prosecutor dismisses charges, it's reasonable to infer that the causation from those two sets of facts.
Exactly. Because I think the problem that you're going to have is you're never going to have a prosecutor go up to a defendant and say, I'm dismissing your charges because I think you're innocent. You're just not going to have that.
That actually does happen. I mean, that's what's in the legislative record of prosecutors saying, wow, we convicted the wrong person. And it strikes me that your argument here is that these prosecutors obtained a guilty verdict that they knew they had the wrong person and they still obtained a guilty verdict. Is that what you're saying?
Well, they didn't retry him. If they really thought that he
would. They obtained a guilty verdict. That's the implication of your argument. And I'm just trying to sort of understand it better.
My argument is that they got this new information.
And your argument is this new information is like a DNA test. It's
correct.
It irrefutably, scientifically demonstrates that your client did nothing wrong.
Well, it shows that what he was accused to have done was unlikely or impossible to have actually have happened.
Does that include the amended charges?
Well, and again, it's going back to that my client, he was very adamant that he was not going to enter a regular guilty plea, and he was not going to enter a guilty plea
Okay.
to the original.
And maybe it's hard for you to talk about, and I understand you don't want to speak in any way that could be construed against your client, but just hypothetically, like, are you suggesting that, I mean, there's a difference between somebody else did it and what you said I did is wrong. I actually did something less bad. Do you see the difference between, and what I'm asking is, with respect to this new evidence, is it, you characterized it as somebody else did it evidence.
Mhm.
But what actually happened is I did something less bad.
Well, I think you can characterize it either way. You can characterize it as someone else did it or I didn't do it. If the person's
Okay.
DNA wasn't at the crime scene, they didn't do it. And I think that's
So just help me understand the evidence here. Your position is your client actually did nothing.
right.
And that this evidence definitively proves that.
Right. And if that would have been shown at his original trial, just like if a DNA test would have been shown saying this person wasn't even at the crime scene, that he likely would have never gotten
So
convicted.
the prosecutors here knew that he was innocent and obtained a guilty verdict anyway.
Well, I mean, I think you can read from the circumstances, you can read everything together and assume that's what their thought process was, that they were not going to be successful on a retrial due to this new evidence.
May I interrupt? I mean, that is one interpretation. But if, you know, what you're asking us to do is jump into the minds of the district attorney, just like you said, you know, to speculate, or it's a reasonable inference that they didn't retry him because he was, you know, not guilty of the charges. And I know it puts it in a really bad situation when you're not guilty of the actual charges, and then they give you a get out of jail free card and ask you to plea to lesser, you know, I did something less bad. But when we're talking about the wrongful conviction statute and we're talking about causation, and I do want to say that your client is the one that bears the burden, right? To prove this causation. How did he prove causation when, I mean, I could see proving causation, you know, they told me that, or, you know, but it doesn't seem like the prosecutor, they didn't dismiss the charges, and they, you know, I mean, even if you construed that they didn't dismiss, you know, that they dismissed those charges and amended the complaint, I'm just not getting this whole, meeting the causation.
Well, going back to my point about, I mean, I think it's going to be very unlikely that you're going to have a prosecutor who's going to flat out say, I think this person's innocent.
This is speculation.
And even further on that, especially if we have a wrongful conviction statute that says the only way that a person can seek relief through this statute is if the prosecutor does that, then
right. But what you're imputing to the prosecutor is bad faith. And I'm not sure that I can, well, I know that I can't just say, oh, you know what? So prosecutors are not neutral. They're not trying to achieve justice. All they're trying to do is get the guy and make sure he doesn't get any wrongful conviction money. Are you saying they were looking ahead to that when they were trying to resolve this? Well, let's just make sure that he doesn't get any wrongful conviction. I mean, you're giving a bad motive to the prosecutors.
Well, I think it's just a dangerous slope to be created. And I think looking at the circumstances in this case, I mean, like I've said, you have this report that comes out that essentially says.
But I understand, but the thing is that we don't create a situation. We didn't write the statute. The legislature has the authority to write the statute. They had tons of hearings, they had testimony. And so we are just required to follow the what the legislature, what the law is. And so whether it creates, we're not creating anything. We're just saying, as we did in Doles and as we did in Sims before that, here's what the legislature is saying. This is when you get the money for a wrongful conviction.
And my argument is looking at this statute, I think this is exactly the type of case that the legislature created this statute for. He's someone who, like I've pointed out, he has this report that was never submitted, and once it was, then that's when his case.
How is this similar to Lamont McIntyre? Okay, where okay, he didn't do it. The prosecutor dismissed the charges against him. Front page of the Kansas City Star, this guy's innocent.
Well, and the other thing
The reason we're dismissing it is because he's innocent.
Well, the other thing that you have with Mr. Mashaney's case too, that was briefly brought up, is you have the victim who actually recanted and said there's testimony in the civil trial of the victim actually later saying, no, this didn't happen. My mom put me up to it and told me.
Did the prosecutor dismiss it because of that? Or if we say it was a dismissal, which I'm not sure I can agree it's a dismissal when they amended the charges down. I mean, dismissal is dismissal. Did it have the same case number?
But I think that looking at the statute and what the intent with it, because obviously every case, it's going to have different circumstances, especially when you're dealing with district court, court of appeals, 1507s. I mean, there's a lot that goes into these type of cases. But I think looking at the big things, which is that you had this report that was in his favor that was never submitted. You have the victim, which the victim.
Again, as Justice Stiegel said, that's all going to actual innocence. It's almost like you're skipping the part about causation.
You're just suggesting that the statute doesn't require direct evidence of causation from the mouth of a prosecutor.
Right.
It can be done through circumstantial evidence.
Right.
And by looking at the series of a sequence of events and what the prosecutor did in reaction to the newly discovered evidence, and that can support a reasonable inference of causation.
Right. Looking at the circumstances of the whole, the court can read between the lines and come to that conclusion. But it's very similar to kind of like going back to those DNA tests, where in this case, the only evidence that the state presented in support of Mr. Mashaney's conviction was the victim's testimony. That was the only evidence. If the court goes back and looks at the record from the trial court, we now have a victim who's recanted that, who said, this did not happen. My mom told me to do this. It's not true. And it's very similar to with those DNA cases that have been brought up, is you have the only evidence being shown to not be right, to not be truthful. And I think that the legislature, looking at this case, if the legislature saw, we have a person who the only thing that he was convicted on was the victim's testimony. And we have this victim who now has recanted and said, it didn't happen. And we have a report from the only scientific report that was involved in this case at all, because the state certainly didn't present any. The only scientific report that we have in this case at all saying it's impossible that this happened. I think taking those things together, I just think that this is something that the legislature this is what this statute was created for, these type of situations. Mr. Mashaney spent 8 years in prison for a crime that the victim later came out and said did not happen. And he can't get that time back. He went through.
How is this different than you have another witness recanting? Every time a witness recants and then it goes back down and they plead to a lesser, or not a lesser, but plead to, why did the prosecutor not dismiss it? I mean, you're talking about circumstantial evidence.
And I think one thing to take into consideration too is Mr. Mashaney was originally sentenced to over 38 years in prison. He did 8, which is a long time, but it's not nearly as long as what he was sentenced to. If the state really believed that he was not innocent, why would they agree to him being let out in 8 years as opposed to the 38 that he was sentenced to? So I think that's one thing too that goes to all the things taken into consideration as to what happened between the time that this case was appealed and then it was later, as our argument is, effectively dismissed based on the circumstances of the Alfred plea. Thank you.
I need to move you. I'm sorry, Chief. I got to take a little time here because as I mentioned to Mr. Powell, this causation thing's a whole can of worms. But there's a threshold legal question before we even get to that, which is whether these charges were dismissed. And the district court said that the charges were effectively dismissed. I don't see how that comports with the Sims case, because Sims says that the dismissal has to mean both terminating the criminal accusation and relieving the defendant of that accusation's criminal liability. Now, we also know that lesser includeds don't work for that. So it's not the charge is dismissed, it's the accusation. And in this case, the accusation is that your client touched an underage girl. Now, the original charges were sex related. The amended charges were not sex related, but it was still ag battery against the underage victim and then endangering a child. You got the same victim, you've got the same touching. I don't see how those facts get you past the requirement of the statute that the charges were dismissed.
My understanding from the reading of Sims is part of that was that the charges that he pled to or were ultimately convicted of were very similar in nature to what his original conviction was. And they were along the same lines. If you look at what,
but in your case, it's same victim and it's touching. The only difference is the sexual aspect of the one versus the other.
well, with Mr. Mashaney, the Alfred plea consisted of was 2 counts of attempted battery. So you wouldn't even have an actual
same victim though, and battery. I mean, attempted battery. Okay.
So, and I mean, that's a misdemeanor charge, as opposed to a level 1 or 2 felony, that he was originally, convicted of for 1. And for 2, Sims didn't have the other circumstances that were present in this matter. Sims didn't have a ineffective assistance of counsel finding based on evidence that was very favorable to Mr. Sims that was never admitted into evidence. Sims doesn't have the only witness who was presented by the state in the original charges to have come out and recanted his or her testimony. You don't have that with Mr. Sims. He entered not only an Alfred plea, but also a plea that allowed him to get out of prison that day, instead of having to sit in prison to await trial. So there's a lot more as far as the surrounding circumstances that are present in Mashaney's matter that weren't present in Mr. Sims. And I would mention too, the district court heard all of this evidence, and the district court specifically made a finding that it made a finding of actual evidence.
It's a conclusion of law what the district court did. This effectively dismissed as a conclusion of law.
What I was going to say too is they made the factual finding that Mr. Mashaney was innocent based on what was presented. And I'd also mention too, the state during that trial did not present any evidence whatsoever as to any evidence in support of Mr. Mashaney's conviction or the original charges, or for any other reason for why the charges were not retried.
would you agree that the Alford conviction is also consistent with the prosecutor not believing the recantation as true?
Can you rephrase that?
Well, if you testify one way,
Uh-huh.
and then you later say, I lied before, I'm telling the truth now, one of those times has to be a lie. If the recantation is true, then the original testimony is a lie.
Okay, I get
The
it.
original testimony is true, the recantation is a lie.
Yeah.
So the Alford conviction is also consistent with the prosecutor not believing the recantation to be true, correct?
Okay, I get what you're asking now. And my response to that would be, so what was presented in the civil court was the daughter actually approached Mr. Mashaney and apologized to him and said, my mom put me up to this. I'm sorry that this happened. The daughter also went to both of Mr. Mashaney's parents, her grandma and her grandpa.
I
and said the
understand
same-
her recantation was repeated several times.
Mhm.
But go back, focus on the prosecutor.
Uh-huh.
Is it consistent with the prosecutor in the criminal case not believing the recantation?
Well, and I don't know what, I mean, based on the circumstances of the recantation, she was older when it happened. So she was, I would argue, at a point where she could more she could speak for herself instead of just mimicking maybe what an adult told her to. She was only 5 when she testified at this trial, when this happened. So when you have a 5-year-old who says one thing, as the child gets older, the child's probably going to be more likely to be able to speak for themselves and not just mimic what a parent's telling them to say.
Okay.
So you have that, and then you also have she repeated that recantation to at least 3 different individuals, including Mr. Mashaney himself, the person that was accused of doing this. She approached him and apologized.
Yes, I
So-
understand. Thank
Okay,
you.
Thanks.
See no other questions?
If there aren't any other questions, I'll step down. Thank you.
Okay, thank you.
May it please the court, I'll be very brief. I want to address what Justice Wall raised about inferences. I don't disagree that you could draw inferences from the record to try to make some findings as to the prosecutor's motive. I certainly think that's possible in these cases. I don't think you have to have necessarily the testimony of the district attorney. But I would respectfully say that in this case, you can't make inferences that the prosecutor thought Mashaney was innocent and that's why they agreed to the amendment. I think the inferences go the other way. And particularly if you know Mark Bennett like I do, that's not part of the record, but he's a straight shooter. He didn't try this case originally. Christine Ladner did, but it was Mark Bennett, who I think at that time was district attorney. He's the one that agreed to this plea agreement and insisted apparently on a guilty plea or an Alford plea. I think that says a lot about what he may have thought.
Yeah, regardless, there may be conflicting.
Right.
You could maybe draw different inferences from the evidence, but at the end of the day, we don't have any findings, right?
Right. That's
the
the fatal flaw right there, is we don't have any findings. Mr. Mashaney's counsel, they could have called Mark Bennett to testify as to his reasons. But the bottom line is we don't have any findings to establish one way or another, and I think that's fatal. Seeing nothing. Thank you very much. The court would just, the state would ask that the court reverse the district court and vacate the district court's judgment against the state. Thank you.
Thank you. Thank you to both counsel for your arguments today. The court will take this matter under advisement. The court is now adjourned.